Now, your lordships may kindly see in Ghaidan, my lord, para 148, I have quoted Lord Nicholas. In this context, kindly read, my lord, my learned friend said that now after Ghaidan, whatever you want to read, you can read into the provision and even alter the statute. That was, my lord, the tall argument which was made, which is, my lord, how legally not sustainable, but the foundation is false. The foundation is that there is an equal jurisdiction between the Supreme Court of India and the UK Supreme Court. UK Supreme Court exercising power of declaring a statute to be incompatible, nothing less than that, my lord. Lord, 147, if your lordship don't mind, if your ladyship don't mind. 84, yes. My lord. It is submitted that despite the wide powers, the court in UK have clarified that the powers are limited, interpreting, not legislating. Even post Ghaidan, we can only interpret, we cannot legislate. In considering that is what is possible, the courts have repeatedly stressed the constitutional importance of maintaining the boundary between interpretation, which is, Lord, this is in quotation, my lord, MacDonald judgment, subsequent to Ghaidan, interpretation which is a matter for the courts and others who have to read and give effect to legislation, and amendment which is a matter for parliament. This is post Ghaidan MacDonald judgment. Now, Lord Nicholas in Ghaidan. Parliament, however, cannot have intended that in discharge of this extended interpretative function, the court should adopt a meaning inconsistent with the fundamental feature of legislation. This was not read before your lordships in Ghaidan, my lord, by the petitioner. In Rent Act, my lord, the essential feature is not whether the marriage is heterosexual or homosexual. It was rent and the provisions concerning that. That would be to cross the constitutional boundary, section 3(6), to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger and Aylesbury, go with the grain of the legislation. My lord, in my respectful submission, this changes the scenario. In Special Marriage Act, grain of the legislation is heterosexual marriage only. Nor can Parliament have intended that Section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. Then Lord Reger, my lord, your lordships may, my lords have, my lord, my lord justice, in same, my lord Ghaidan, my lord concurring. What excludes such provision from the scope of section 3(1) is not any mere matter of linguistic form in which Parliament has chosen to express the obligation. Rather, they are excluded because the entire substance of the provision, what it requires the public authority to do, is incompatible with the convention. The only cure is to change the provision, and that is a matter for Parliament and not for the courts. They, like everyone else, are bound by the provision. Ghaidan says this, which, my lord, was not assisted with, my lord, by the petitioner to your lordships.
Actually, you can see the last portion of that.
Lord,
page PDF 85. 85.
Yes, my lord. 85.
The last
yes.
highlighted.
Well, that is impossible. Yes, my lord. May I read, my lord, the first part also? It does not allow the courts to change the substance of the provision completely, to change a provision from one where Parliament says that X is to happen into one saying that X is not to happen. Then, my lord, bold portion at the foot of this para. For instance, the Court of Appeal held that I'm sorry. It was impossible for the court to use the interpretative obligation in section 31 in effect to recreate the fixed penalty scheme enacted by Parliament so as to turn it into a scheme that was compatible with Article 6. As Simon Brown, Lord Justice, observed, it would have involved turning the scheme inside out, something that the court could not do. Only Parliament, not the courts, could create a wholly different scheme so as to provide an acceptable alternative means of immigration control. This is the ratio of Ghaidan. Now, your lordships may allowed to kindly see para 149.
He uses stronger words like judicial vandalism.
My lord, I didn't read it, my lord. In fact, my lord, this is still, my lord, British language. American judgments are more harsher.
Very sharp.
Very sharp.
Very sharp, my lord. Very.
Because they are not always career judges, you see, in the American Supreme Court. They come from public policy backgrounds, from academia.
They use even sarcasm.
And justice judgments are extraordinarily trenchant.
Justice Kalia, my lord. Justice Kalia. Lord, Justice Kalia in this, my lord, Oberfläche has used sarcasm, my lord, while dealing with further judgment. But, my lord, that.
Yeah, absolutely.
Lord, para 149. Judicial vandalism, Lord, I avoided reading that part, my lord, but it's not, my lord, I'm just only reading, my lord. It is submitted that discussion of the boundary between legislation and interpretation has tended to focus on two factors. First, it will not be possible to construe legislation in a convention-compliant way if to do so would be inconsistent with some important feature of the legislation. The grain of the act, my lord, as they say. And grain is heterosexual, right from the debates till the language used. Secondly, the courts, even in UK, have shown a reluctance to place creative reliance on Section 3 in cases involving complex questions of social policy, which the courts are ill-equipped to decide and which are therefore best left to Parliament. The earlier authorities prior to Ghaidan and after HRA, which were summarized by Lord Brigham in so-and-so versus so-and-so, it was held that a convention-compliant interpretation may not be possible where it would be incompatible with the underlying thrust of the legislation or would not go with the grain of it or would call for legislative deliberation or would change the substance of a provision completely or would remove its pith and substance or would violate a cardinal principle of the legislation. Well, this is before Ghaidan and after the Human Rights Act, my lord, came into effect. Lord, kindly, my lord, come to the next page, my lord.
Yeah, Ghaidan was 99.
Ghaidan was 99. So the Human Rights Act came into force in 1998.
98. And this judgment, my lord.
Ghaidan is 2004.
No, Ghaidan is 2004. I'm sorry.
2004.
2004, my lord.
It's after the act.
It's post-act.
So between 98 and 2004 comes, my lord, this Sheldrake. Justice.
But the interesting part is that concurrently with Ghaidan, you have that Civil Partnership Registration Act in 2004, around that time. So there was a move there.
Yes, my lord, contemporary move. But that was discussed, debated in public, and thereafter brought by way of a legislature, my lord. And Ghaidan was not concerned with that issue, my lord. On the subject matter before Ghaidan was not that issue.